I'm working on human rights since the beginning of my job as a lawyer. I was involved in human rights when I was a student, and it was one of the reasons that I was chosen this profession. I was working also with different NGOs, and last 20 years in particular with Avocats Sans Frontières, Lawyers Without Borders. I was actually involved in the very first case since 2006, when Mr. Thomas Lubanga was arrested. It was, in fact, through Avocats Sans Frontières, who was working in DRC, in particular with victims of war crimes in that country, that I was contacted and asked to represent a group of victims they were in contact with. I'm the only European consul, so all the victim representatives are people from the DRC, in a position with the counsel of the accused, where no one is from the DRC. So very often during the trial, it were also counsel from the victim side who brought up some practical issues that even the prosecutor was not aware about. For instance, we discovered during the evidence that there was a huge problem with names of witnesses and other people involved, and it was the initiative of the Congolese legal representatives to propose an expertise and to bring to the court a Congolese language expert who is especially an expert in names, in Congolese names, and the way that Congolese people can have different names, change their names. People can use another name in other circumstances, and this is not fraudulous, it's just a culture. I think it's quite important that female lawyers are involved in the procedures, not only as counsel, also on the level of the prosecution, for instance. It's also important that the particular situation of the women in the case is brought up. In our situation of child soldiers, for instance, the prosecutor's office, notwithstanding the fact that a lot of women were working with them, he didn't discover that enrollment of children in a militia means for the girl soldiers sexual violence and sexual slavery. So this aspect was brought up by the legal representative of victims, and in particular indeed also by women representatives. The case is brought by the prosecutor. We are not in contact also with the victims the prosecutor discovered. We are in contact with our own clients, although some of them can have a double status, but most of our clients were not victims of the prosecutor. So we discovered also some aspects of the case that the prosecutor was not aware of it, and he was sometimes not aware because he didn't ask the right questions. If in his mind the only issue is to know if a child, girl or boy has been abducted or recruited in a militia, if he don't ask if there was this aspect, the girl will not generally tell that from her own initiative. And it's even sometimes quite difficult for the victims to think about that and to bring it up. Also my experience, for instance, in a Belgian case linked to the genocide in Rwanda, where we had 30,000 pages of questioning documents in the case. Not only questions, but a lot of evidence was just interrogation of witnesses, and in particular a group of women witnesses that during 14 days were kept like prisoners by the Interhamwe. So no investigator was asking what happened exactly there. It was discovered during the trial. Fortunately, the prosecutor focused only on the very fact of children recruited in an armed group, not on the conditions of that recruitment. Although, of course, for the victims, and even from a general public order perspective, there's a lot of difference between accepting a boy of 14 years to be member of an armed group, or abducting children from a school, treating them with violence and sometimes torture and executions and so on. And of course, at the side of women and girls, sexual slavery. So, in our opinion, it was part of the very fact of recruitment, in the sense that in the particular context of the DRC, decision of a leader to recruit on a large scale, not only boys but also girls under 15 in an armed group, you cannot imagine that there would not be sexual violence against that. So we tried to obtain that the chamber add this qualification, or better interpreted the qualification by and enlarged it. But on the appeals level, it was accepted even by the chamber, but at the appeal level it was changed. Role of intermediaries was really essential. We had as clients children, not even concentrated in one city, but living in different villages in an area. It would have been very difficult for us to contact every person personally, because they don't have phones, they don't have email, etc. We had indeed people from local NGOs who were in contact with those clients and who could play this role to bring the people to us and to organize a practical meeting with them. We were working with NGO people. They support the victims in the framework of their NGO work. I think it's quite dangerous when it becomes a job. That's a difficult problem, because at the one hand, something that in the beginning is just a helping hand can become very energy consuming and even cost consuming. Personally, I don't like a relationship where intermediaries are paid and where it becomes a real job. There is a discussion on the court if that, and on the level of the registry and the court as a whole, if there should not be a kind of status of intermediary where it becomes more or less like a job, where you have people responding to certain criteria. Everybody should try to have as much as possible to have a direct contact and to limit the role of intermediaries to bringing people together, either than to transmit the content of messages. It's clear that young people who went through a period of child soldiering when they were very young, they are damaged in general. Girls indeed generally have been raped and so on, and the community knows about that. They were bushwives and so on. It's difficult for them to find a husband. But also for the boys, it's has an influence on the development of the character, of course. And this is not very positive. Some of them could overcome it. So some of our clients, they have a job, they founded a family, and they build up again a new life. But a lot of others are very marginalized. For child soldiers, the problem is also that they are not seen as good people, and because they committed crimes when they were in the militia, even if they were ordered to do so. They killed people from the other ethnic group, but also sometimes in their own ethnic group they forced people to give food. It would be better, of course, in the future if also in other areas where you have serious war crimes and crimes against humanity, cases out of Africa come to the courts, like now in Syria and so on, but it needs a decision of the Security Council or an acceptance of the countries concerned. I think it can certainly be useful to do that kind of research, also to support a trust fund for victims, because the trust funds, even out of any conviction, can support reparation programs in the situation countries. So they could, even in the context of Sudan, the trust fund could organize some support for victims. And the trust fund needs indeed support because they are working mainly with voluntary contributions. The funds available are not very important. So if they can be assisted by NGO programs like that, it can certainly be very positive.